So America has come to a crossroads. For the last week and a half, we've been watching a circus unfold in the U.S. Senate, specifically in the Judiciary Committee, with regards to whether or not the accusations against Judge Brett Kavanaugh should be believed. One way or another, this situation will be resolved. Either Judge Kavanaugh will be exonerated and confirmed, or he will not be confirmed and someone else will be put in his place. One way or another, the nation will move on. But this calls to mind a much more interesting, much more important issue. The question of presumption of innocence. Presumption of innocence, according to many people, should only apply in a court of law. However, this has not been historically the case. Presumption of innocence is not simply a construct of the U.S. Constitution that is only applicable in legal forms. It is a moral obligation which goes back thousands of years. In the book of Deuteronomy, we're told that in the absence of two witnesses, an accused individual may not be convicted. Roman law, going back over 2,000 years, stated that one witness is no witness. A single witness, an accuser, is not sufficient to prove that someone is guilty. Blackstone's formulation, which Ben Franklin famously paraphrased during the early days of our republic, tells us that it is better for 100 guilty men to go unpunished than for a single innocent man to be unjustly punished. That simple truth, that simple axiom, that simple reality of what justice is so important in our society. There are other countries in the world where they presume guilty rather than presume innocent, and then the accused has to prove his innocence. We've seen it in places like the Soviet Union, like places like the People's Republic of China, and North Korea, and Cuba, and Pinochet's Chile, and fascist Italy. We've seen it everywhere tyranny exists. But in free societies, we do not presume the accused to be guilty. We do not demand that the accused prove his innocence. Simply put, accuser and accused are not equal. Accuser and accused are not standing in balance in front of society. Accuser has 0% of the benefit, and the accused has 100% of the benefit. And the accuser, or those who represent the accuser, such as prosecutors or plaintiff's attorneys in a civil case, are obligated to make that entire case, to meet that burden of proof. And the accused has no responsibility to even testify or to present a case. He can sit there silently, and if the accuser does not make his or her case, guilt cannot be determined. He is innocent. And until the moment that he is judged guilty, he is 100% innocent. Not 50%, not 75%, not 25%, 100% innocent in all cases until guilt is proven. Now, why is it important that we do this in society, outside of a criminal court? Because the so-called court of public opinion is reckless, it is vicious, it is irresponsible. The court of public opinion convicts those who have never had any evidence against them presented, simply because people make their decisions based on emotions, and emotions are invalid when it comes to making decisions. They fool people. They lie. Facts cannot lie. Math cannot lie. Emotions lie all the time, and they should never be trusted. Emotions need to be jettisoned when it comes to this process. Evidence, hard facts, hard math, truth as presented with corroboration. That's what matters. And so, right now, what we are facing is a watershed moment for our country. Do we continue to walk down the path where presumption of innocence is held sacrosanct? Or do we, as Americans, become the Soviet Union or Cuba or Red China, where we will convict anybody based on an accusation and nothing more? We cannot do that. This is not about Judge Kavanaugh. It is not about Christine Blasey Ford. It is not about Dianne Feinstein. It is about justice. And justice demands that those who are accused without evidence be deemed innocent until the very last moment when they are proven guilty. Nothing but the presumption of innocence has any value in this debate. Nothing. The Founding Fathers would be ashamed of those in America who do not give proper weight to the presumption of innocence. We have three basic rights that protect our freedom. The first is our right to life. Nobody can take that away from us, not legally. The second is our right to bear arms, so we can defend our right to life and defend our freedom. And the third is the presumption of innocence, because that is what protects us from being thrown in prison, from being impoverished by fines, and from having our lives destroyed by the court of public opinion. Nothing in the process of justice, whether in a court of law or the court of public opinion, or in any other forum, must ever be allowed to outweigh the presumption of innocence. Absolutely nothing. Because that is who we are as Americans.